Call the meeting to order. It is 10:02, and just wanted to introduce myself. I'm Grayson Gill, the new presiding officer, and look forward to working with everybody. Remember just to mute your microphones when you're not speaking, and also say your name before you speak, since we are on a recorded line, and some people may not be watching a video but listening in without the video component. So with that, we will kick off. Alex, do you want to call the roll and determine if we have a quorum, please, sir?
Yes, sir. Okay, Mr. Scott Anderson.
Present.
Ms. Sheila Sweat.
Present.
Mr. Brian Mitchell. Mr. Brian Morris.
Present.
Mr. Jerry Matheny.
Present.
And Mr. Greg Temez.
Presiding officer.
And Mr. Grayson Gill, presiding officer.
Present.
Okay, it looks like we have a quorum, sir. And if I could just remind the board members, if you could please turn on your cameras during the meeting.
Great. Thank you, Alex. So we'll proceed with our agenda. Chris, do you want to work through some more general counsel training?
Yeah. Can everyone hear me all right?
Yes, sir.
Thank you, Chair, Mr. Chair, board member. I'm Assistant General Counsel Chris Funderburk. I'll be going through the open government training the government is required to give to the board members each year. This training covers 3 statutes, and each require transparency in government and public participation. Excuse me, just one moment. I'm getting a little echo on mine. Oh, you got it. Oh, thank you. Okay. The training covers 3 statutes, and each requires transparency in government and public participation. These statutory mandates impact the function of each advisory board associated with TDLR in this presentation. The first statute that we'll discuss is the Open Meetings Act. Second is the Administrative Procedure Act, also called the APA, and the Public Information Act is the third, also referred to as the Open Records Act. And we'll start with the Open Meetings Act in Chapter 551 of the Government Code. Next slide, please. Oh, I go one more. One more. Thank you. So the purpose of the Texas Open Meetings Act is to ensure open and transparent government. This act requires meetings of governmental bodies to be open to the public and to be preceded by public notice of the time, place, and subject matter of the meeting. The provisions of the act are mandatory and to be liberally construed in favor of open government. Next slide, please. So there are 3 key terms associated with the Open Meeting Act: quorum, deliberations, which are alternatively discussions, and meetings. These are terms of art that have specific meanings within the Open Meetings Act, and which we'll discuss further. So next slide, please. Oh, no, I'm sorry. Stay on the front. A quorum is a majority of the members of the advisory board as fixed by statute or rule. A quorum of the governmental body, including an advisory board or committee, must meet in order to take an official action. So, thank you. Deliberation or discussion means a verbal or written exchange among a quorum of a governmental body or between a quorum of a governmental body and another person, for example, during public comment period, concerning an issue within the jurisdiction of the governmental body. There, as you see, there are several components to this term, which will become important later on in our discussion. Next slide, please. Meeting. A meeting occurs anytime that a quorum of a governmental body engages in deliberation regarding public business or public policy over which the governmental body has supervision or control, or anytime the body takes formal action. Of course, a body can't take formal action without a quorum. However, a deliberation can occur between by a governmental body, even though a quorum doesn't exist. However, no formal action could be taken at that time. Next slide, please. So if we've reached the threshold of a quorum taking official action or a quorum engaging in deliberation, then the provisions of the Open Meeting Act notice attached to that the deliberation or official action. The act requires advanced written notice of the date, time, place, and subject of each meeting that is held. PDLR provides this notice in the form of an agenda. Notice must be filed with the Texas Secretary of State at least 7 days before a meeting. It must be posted online both by TDLR and the Secretary of State. A board or committee may not engage in any discussion about a subject not included in the agenda. Next slide, please. So what about things like social functions, conventions, and workshops? Keeping in mind that a meeting occurs whenever a quorum of a governmental body engages in discussion about an issue within the governmental body's jurisdiction, can members ever meet in an informal setting without violating the Open Meetings Act? Yes, members are free to engage in conversation that is incidental to the event. However, if the discussion will be subject to the Open Meetings Act if a quorum of members is involved and the members either engage in a discussion or make decision about board committee business or take formal action. If the members of a board are at a farmer's market and are discussing the price of eggs, the public doesn't need to be placed on notice about this. This is subject matter that is outside of the board's governmental body's jurisdiction, and the public doesn't need to be aware so that they could weigh in on that commentary. So, next slide, please. So always be aware of any situation occurring outside of a properly noticed meeting in which a quorum of members is present or engaged in discussion. Do not engage in substantive conversation relating to board or committee business or policy when a quorum is involved and you are outside of the officially noticed and scheduled meeting. And this leads into the real risk of the walking quorum. So give me one moment. I think that this concept may benefit from a little more discussion, so I just wanted to provide a few examples. The formation of a quorum isn't limited to a specific time or location. Rather, quorums form through communications between board members. These communications can easily occur outside of a formal meeting, and the communications can stack on top of each other, often without the board members realizing it. This reality creates the risk of a walking quorum. A walking quorum occurs when fewer than a quorum of members engage in a discussion about official business, then communicate those discussions to other members. If a sufficient number of board members are involved in this discussion about official business, the threshold of quorum is reached, and the meetings requirement of the open record of the OMA attach. While fewer than a quorum of members participate in initial communication, subsequent communication with other members will result in a quorum discussing official business outside of a public meeting. Next slide, please. So, for example, on a five-member advisory board, 2 members exchange phone calls and emails expressing thoughts on an upcoming rule change and exchange research that they have individually performed regarding licensees. At this point, with a 5-member board, 2 members are less than a quorum. This is the OMA requirements do not attach. Then one of the board members subsequently forwards the exchange to another member. Now the members have engaged in a walking quorum by engaging in a small group discussion outside of a properly noticed board meeting about a subject matter that was within the governmental body's regulatory jurisdiction. So, and at this point, the open meeting requirements attach, and that's when complications arise. Next slide, please. Walking quorums can occur during conference calls, video conferences, hallways discussions, emails, text messages, and other new technology. The walking quorum concept, combined with newer technologies such as Twitter, Facebook, and instant messaging, raised new issues about meetings and compliance with the Open Meetings Act. Now we have discussions hovering in the cloud that other people can join on at, days, weeks later. And with the combined communication of multiple board members reaching that quorum threshold, now we've got an open meeting problem. Next slide, please. Best practices to avoid a walking quorum. To avoid a walking quorum, members should not meet in small groups, discuss board or committee business, and then communicate these discussions to other members. And when we say small group, we mean here less than a quorum. Board members should not send emails or text messages to a quorum of members regarding official business, even if each email is addressed and sent to each member individually. Board members should not create posts on social media about board business where a likelihood exists that a quorum or members could participate in discussions. And again, I think it's important to point out your social media, your involvement with social media does not raise the risk of walking quorum if the subject matter of your discussions on social media don't implicate the subject matter of the governmental body jurisdiction. It's when you start talking about things that are within that jurisdiction that creates the potential quorum issue. Board members should not ask a quorum of members, even on an individual basis, for feedback on or comments on board or committee business outside of the public meeting. This is also called polling, which is essentially conducting an informal vote on an issue. Next slide, please. Guidelines for open sessions. A board or committee is limited to discussing the specific items on the agenda. During the public comment portion of the meeting, members of the public are given an opportunity to speak, and the presiding officer may set a reasonable limits on commenters. A member of the public or member of the board may raise a subject that has not been included on the agenda. However, any discussion on the subject must be limited to the proposal to place the subject on the agenda for a future meeting. This is why the board members cannot engage in back and forth deliberation or discussion with public commenters, as the public commenters, the subject matter of their conversation is unknown at the time that the agenda is created, and the public could not possibly be put on notice of the subject of that discussion and the board members' response to it. Next slide, please. Guidelines for open sessions, best practices. To avoid violating the act on the basis of insufficient notice, members should limit discussion to the specific agenda items contained in the posting filed with the Secretary of State. Avoid allowing discussions regarding specific agenda items to wander off course into new issues that have not been noticed to the public. Not respond or discuss issues that are raised during public comment, but which are not on the agenda. And specifically identify items for future agendas and communicate these items through TDLR staff. That way we can put them on the notice for the next agenda and you can discuss them freely. Next slide, please. Now the hammer. Penalties and remedies for Open Meeting Act violation. Civil remedy. Any interested person, including the media, may petition the court to stop action taken in violation of the Open Meetings Act. The Open Meetings Act also specifically states that an action taken in violation of the act is voidable. So an official action that is in violation of the Open Meetings Act is potentially voidable and can be undone simply by court action. Next slide, please. In addition, there are criminal penalties associated with violations of the Open Meeting Act. Members who knowingly participate in a walking forum or who knowingly participate in a meeting that is closed to the public are subject to misdemeanor criminal penalties. These penalties are a fine of $100 to $500, confinement in a county jail for 1 to 6 months, or both the fine and jail time. Probably speaks for itself. Next slide, please. Best practices of the Open Meeting Act. Avoid communications that involve a quorum of board or committee meetings about official businesses outside of a properly noticed meeting. And the communications here obviously are deliberations, discussions about subject matter within the board's regulatory jurisdiction. And also during open meetings, confine discussions to items specifically posted on the agenda. Next slide, please. And here are some additional resources. Texas Attorney General has a variety of well thought out and well designed handbook that can provide additional information on what we've discussed today. I did want to take this moment to briefly discuss, because I think it's going to come up later during our board meeting, the concept of work groups. So if less than a quorum of members discuss an issue within the jurisdiction of the governmental body and take no formal action, this discussion is not a deliberation, but using that as a term of art. Thus, the Open Meetings Act requirements do not attach to that discussion. For example, the board may want to research and analyze a specific issue of interest to the profession within the board's jurisdiction. In that event, the issue may be assigned to a work group comprised of members of the board as well as department personnel. If the number of board members assigned to the work group is less than a quorum, the work group can meet without triggering the OMA's notice requirements. They do not attach even though the board members are discussing an issue within the jurisdiction of the governmental body. That is, as long as the board members assigned to that work group do not share their discussions with other members of the board, as this could result in a walking quorum. That said, the next time the board officially meets, the work group can share the results of its discussion with the other board members and the work group, and assuming that the work group's presentation is included on the official agenda. We're going to move now to the second set of with the Administrative Procedure Act. Were there any questions about the Open Meeting Act?
Grayson Gill speaking. No, Chris, I was just going to thank you for covering that because obviously that was on everybody's mind as we get to the work groups. Appreciate that.
You're welcome. Happy to help. We'll turn to the Administrative Procedures Act. Excuse me. Thank you. So the Administrative Procedures Act, the purpose is to establish minimum standards of uniform practice and procedures for state agencies and provide for public participation and transparency during the rulemaking process. Next slide, please. The rule has a specific definition within the APA. It's a statement of general applicability made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. Next slide, please. A rule excludes a statement regarding only the internal management or organization of a state agency and not affecting private rights or procedures. The distinction that's being made here is between rule and procedures or processes internal to the organization itself and not affecting the property rights of licensees. It's a contentious area, but one that we try to make sure we are on one side of the line or the other. A rule includes a new rule, an amendment to an existing rule, and the repeal of an existing rule. Next slide, please. Sources for rulemaking include legislative mandated changes, suggestions from advisory boards, CBLR staff's own suggestions, the 4-year rule requirement by mandate, and by rule petition from interested third parties. Next slide, please. Being a rule petition, any interested person may submit a petition to a state agency requesting the adoption of a rule. An interested person is anyone who is a Texas resident, a business entity located in Texas, a governmental subdivision in Texas, or a public or private organization that is not a state agency but is located in Texas. Here's this is a flowchart for the Administrative Procedures Act rulemaking process. I won't read it to you, but it is a complicated procedure with multiple steps, and it can take a considerable amount of time. But I think the reason for this involved procedure is to make sure that the public is aware of the rules that the agency is attempting to promulgate and has ability to make input and suggestions at the, I won't say every step, but at the crucial step prior to publication and it becoming a enforceable administrative rule. Next slide, please. So the rule review process again is the program's on a 4-year schedule. We publish a notice of intent to review. Public has 30 days to comment, and this is distinct from the rulemaking process. These are two sides of the same coin. The prior was the rulemaking process. This one is the rule review process, generally, which is triggered on a 4-year basis by legislative mandate. It's a slightly simplified version of the rulemaking process, but again, I think you can see that its design is to ensure that the public has an opportunity to weigh in on the rules that could potentially affect their profession before publication. Next slide, please. And once again, the Texas OAG has provided a very well thought out rulemaking handbook. If you'd like to investigate further, there's also the code itself is available online. And if you ever have any questions, please feel free to contact our general counsel's office at the number at the bottom of the screen. Finally, we get to the Public Information Act. The Public Information Act, or Open Records Act, is intended to allow public access to information about the affairs of government and the official acts of public officials and employees. The act makes all documents, records, and other information relating to official business open to the public with some exceptions. Public information includes any electronic communication created, transmitted, received, or maintained on any device if it is in connection with official agency business. And this act should be construed liberally in favor of granting any request for information. Next slide, please. Request for public information. The public may request copies of public information or request to inspect the information in the offices of the governmental body. A request must be submitted in writing. However, writing can also be in electronic format. At TDLR, a request must be submitted through the TDLR Record Center, which can be accessed on the TDLR website. And there are strict timing rules for the department's response. TDLR must respond to a request as soon as possible, but not later than 10 business days after receiving the request. We cannot ask why someone wants the record. We can only ask for clarification through the GC Open Records team, who, as you might imagine, are incredibly busy. Next slide, please. The Open Records process, general rule and common acceptance to disclosure. The general rule is a presumption of openness. So that's that presumption has to be rebutted in order for the information to not be disclosed. Certain information is required to be redacted from open records. Examples include date of birth, most email addresses, driver's license, license plates, SIN records, credit card numbers, HIPAA information, Texas Medical Records Privacy Act, electronic medical records, and paper medical records. An OAG ruling must be sought to redact or withhold other information. Next slide, please. A request received by an advisory board member. As an advisory board member, if you receive a written request for records or correspondence that looks like a public information request, please forward the request ASAP to the advisory board team, who will forward it to the Office of the General Counsel's Open Records team. If the GC Open Records team requests information from you as an advisory board member, please respond ASAP. The 10 business day deadline applies to all requests, and I don't want to speak out of turn, but I think the deadline, the timer starts on the day that the advisory board member receives it, not on the day that the GC Open Records team receives it. So we're trying to minimize the amount of time between your receipt and our receipt, just to give our Open Records team enough time to finalize, complete, and thorough response. Next slide, please. And again, Public Information Act, OAG has great training, information, and video, also a handbook available. And again, if you have any questions about any aspect of this, of the Public Information Act or anything that we've discussed, please feel free to contact our General Counsel's office whenever you feel the need. That concludes our training. Again, do you have any questions? All right, hearing none.
Grayson Gill speaking. Thank you, Chris. Appreciate it.
Of course.
Okay, we're going to move on to the approval of our minutes from our last meeting, which was in August of 2018. I'm sure everybody remembers that day very well. We did circulate that on before the call in the package. So does anyone have any comments regarding the minutes of that date, August 22nd, 2018? Hearing none.
I move to approve.
For a second.
Scott Anderson, seconds.
Great. Alex, do you want to call roll for a vote?
Yes, sir. First, could I have, who was it that made the original motion?
Sorry, Brian Morris. I move to approve.
Okay, thank you. Okay, Mr. Scott Anderson,
Approve.
Ms. Sheila Sweat,
She's muted.
Sheila, you're still muted. There we go.
She's
Trying
trying to
find
find
the
it.
unmute.
Oh, there we go.
Approve.
Thank you. Mr. Brian Mitchell. Mr. Brian Morse.
Aye.
Mr. Jerry Matheny.
Approved.
Mr. Greg Tamans. You're muted, Mr. Thomas. Okay, Mr. Grayson Gill.
Approved.
Okay, the motion passes, sir.
Grayson Gill. Thank you. Thank you, Alex. Appreciate that. Appreciate everyone participating. We're going to move on next in our agenda to the public comment portion. This is where any person wishing to address the board must submit an email and following the public comment instructions found on the text last page of this agenda or located at the TDLR website by Monday, October the 7th. Obviously, we did not receive any emailed public comments is what my understanding is from the notes, but staff feel free to chime in if something came in after this was sent out. I'll pause for a minute. Great, thank you. Moving on to the next item on the agenda, staff reports. We're going to start with the licensing division. Tiffany, we'll give you the floor.
Actually, that would be read by Yvonne
Great, Yvonne, go ahead.
Lopez.
Good morning, Yvonne Lopez, licensing manager for this program. Before you, you have the statistics for fiscal year 2024 and fiscal year 2023. You also see the current projects where we were reorganized on August 15th. That reorganization created a fourth team and reallocated staff to more evenly distribute our workloads. And as a result, we have assigned all staff to assist with processing elevator inspection reports. And that has significantly reduced processing time. So we're really excited about that. Well, I'll be happy to answer any questions that you may have.
Madam Chair, Mr. Chairman, I have a question.
Yes, sir, go ahead.
Yeah, this is Brian Morris. So back to 2018, 17, 16, we always had some discussions about the inspectors. It was always seemed to be hovering around 160, 180. I think part of the questions and discussion was, so I see currently the population of inspectors is 186. There's a lot more equipment that's come online in the last 6-8 years. Is that adequate amount of inspectors for all the building owners to be keeping up with their inspections? Or is Texas short on QEIs?
Mr. Morris, I will leave that question probably to our compliance division. And then just to clarify, the fiscal year population for 2024 is 180. And the fiscal year 2023 population was 186. It could still be 186. It's just a matter of when the inspectors renew their license. There could be 6 inspectors that have not yet renewed their licenses or are maybe renewing late. But the current population is 180.
Grayson Gill speaking. I know Edmund's on, just didn't know if you wanted to comment, Edmund, on Brian's question.
Couldn't hear what he said. Can you repeat your question, please?
Sure. Again, Brian Morris. The current population of inspectors is 180. Texas is a big state. There's more equipment that's come online since 2018, since we last met. is that enough inspectors for the state to cover all the equipment adequately in the state of Texas?
At this point, the inspectors are covering the areas that need to be inspected. However, we are having several inspectors that are retiring or have passed away. And we have I believe 6 new inspectors have come in to get their licenses in the last about 3 months.
Okay,
Grayson Gill speaking. Brian, sounds like the same problem we're all experiencing in all aspects of the industry. It's just retirements and trying to get, new people into the business.
sure, I understand the QEIs are very skilled, highly, you need experience. You just can't come out of school or anything and to become a QEI. I'm actually in El Paso, and it's always been a problem and issue with so few QEIs out here. And the last time I was involved in some inspections, they would somebody would show up and try to do 12, 18 hours worth of inspections a day to blow into town, do inspections, and then leave. Obviously, the whole licensing is on for the owner to get the inspections done. But if there are areas where there are shortages and there's not enough hours in the day to get it done, don't know if that's a problem or how to solve that problem. Sorry, I guess that was more of a statement than a question. But anyway, we'll keep going.
Okay, Grayson Gill speaking. So we'll keep you posted, Brian. Obviously, that's going to be an ongoing review, and Edmund, feel free to chime in if you're starting to see challenges that we may be able to help you with in terms of trying to recruit more inspectors and try to work on those gaps where markets are like El Paso are hard to serve. Thank you, Yvonne. Let's go next to Customer Service Division, Claudia.
I'm so sorry, I was muted. Are you able to hear me now?
Yes, ma'am.
Thank you. Good morning, advisory board members and TDLR staff. My name is Claudia Enriquez, and I'm the customer service manager for this program. As you can see from the report in front of you, our statistics report shows that we did have an increase in contacts for FY 2024 in comparison to FY 2023. I did not have the statistics when our report was due for the month of September, beginning the FY 2025, but there was a slight increase in contacts for the month of September so far. Other than those statistics, I'll be happy to take any questions you may have.
Brian Morris again. So in today's age society of emails, I guess I'm curious why there are still so many calls coming in instead of emails.
For the most part, we have noticed that people do prefer that one-time phone call just to kind of ask all the questions that they have. A lot of times people will, if they email and their question is answered, it can sometimes lead to further questions, additional questions, and most people typically just prefer to call. We wish that they would use email more often, but unfortunately that is not the case.
So how does this compare to some of the other programs? Is it across the board? Is it typically people are calling more than emailing?
Yes,
Okay.
that is correct. Mm-hmm.
All right. Thank you.
Thank you.
Grayson Gill speaking. Any other questions for Claudia? Great. Thank you, Claudia.
Thank you.
You bet. Okay, we're going to move on next in the agenda to enforcement divisions. Cynthia, you have the floor.
Thank you. Good morning, board members. I am Cynthia Marple. I'm a prosecuting attorney with the Enforcement Division, and I will cover some highlights from our report. We have updated our report format, so we are now showing statistics and information side by side for the fiscal years, so it's easier to compare the different information. And we're also using the same number of months from each fiscal year so that you're getting closer to an apples to apples comparison. So I believe for this report, we're looking at September to July for fiscal year 20.
Cynthia, I'm sorry to interrupt, but your mic is going in and out. I don't know if it's on a wire, if you could keep it steady.
My camera.
It's your microphone.
My microphone. Okay, give me a second.
Okay, thank you.
Better?
No, it's still soft. But it was going in and out. It was getting louder and then softer again.
Let's see.
Okay. Oh, now we can't hear you.
Better?
This is Grayson speaking. I'm not sure if somebody else can cover some of this material for Cynthia since we can't hear her.
Can you hear me better?
Oh, yeah, it keeps going in and out. If there's like another webcam you can use or another mic, and we can come back to you, if that's okay, Mr. Gill.
Sure, we'll do that.
Thank you.
Sure. While we're working through that, let's drop on down to education and examination. John, we'll give you the floor.
All righty. Good morning, presiding officer and board members. My name is John Schildwachter, and I represent the Education Examination Division. Today, I will present our statistics to you. Can everyone hear me okay? Okay, very good. So moving right along, you see the current fiscal year, last fiscal year, and also FY 2023. You see our statistics for responsible party continuing education courses. They're in front of you. You can see there's been some variation, but overall it stayed fairly consistent between the current fiscal year and the last fiscal year. I believe that's my only slide. I'll be happy to answer the questions to the best of my ability if you have any.
Mr. Chairman, this is Brian Morris.
Yes, sir.
So again, maybe a statement here, education. So for all of us older members, Scott and Greg and Grayson, I believe in 2018, we were only into the second, maybe third year of continuing education. So from our vantage point, it was a brand new program. So I assume since we're 8 years later now, or 6 years later, this is a pretty mature project and program, and that there's no challenges for schools, programs, having enough continuing education for contractors and QEIs. Is that a fair statement, that it's all mature and running very smooth now?
To my knowledge, I'm not aware of any issues with availability or continuing education courses or anything of that matter. I have not heard anything along those lines.
Okay, thank you. Sheila, do you concur with that? Is there enough continuing education programs out there that you're aware of?
The continuing education, the only ones I'm aware of are the ones that give the license to the QEIs. And I think there's three of them. But I know of no others.
Okay, very good. Thank you.
Grayson Gill speaking. Thanks, Brian. Thank you, John. Appreciate it.
Thank you.
You bet. Moving on to our next topic of the staff reports, we've got Compliance Division. Edmund, you have the floor.
Thank you. The Compliance Division statistics showing the plan reviews, new installations, alterations, waivers, and delays. There's been increase in the plan reviews. And part of that is going to be, we've had a lot more construction going on and a lot more existing buildings that are updating their equipment. The plan reviews for 2023 were 1886, and the plan reviews for 24 were 2489. So that's a little over a 30% increase. The new installations for the year 2023 were 1137, and for 2024 they are 1764. Alterations for 2023 total was 749, and for 2024 were 725. Waivers for 2023, the total is 11. 2024, the total is 10. Delays for 2023, the total is 28. And for the year 2024, the total is 15.
Grayson Gill speaking. Edmund, real quick question on your reported incidents in 2024. What's the accident? Can you give us any details about the escalator accident on 2024?
So the accident that occurred is still under investigation. I can give you general comments regarding the accident. When we did our investigation, we noticed that there was some violations that occurred from the standpoint of the mechanics performing their work, and also the elevator contractor, and not following the A17.2 guidelines for witnessing the tests that were performed. consequently, in that particular case, because these guidelines were not followed properly, an accident occurred. So, I don't know how much more detail I can go into at this point because of the ongoing investigation.
Grayson Gill speaking. Understood. Just keep us posted. You know, we'd like to hear a little bit about that so we can determine whether or not there are things that we should be changing or looking at to help prevent those, and appreciate your guidance and assistance on that. Back to you.
Yep. Scott Anderson, jumping in real quick. Can you give us a little sense on that escalator accident? Was it a cone plate? Was it a fall? Was it a sidestep and trap? What kind of accident was it?
Excuse me,
accident
Mr. Presiding Officer. My name is Derek Burkhalter. I'm a Deputy General Counsel for TDLR. I'm going to ask that we not discuss any details concerning an incident and an ongoing investigation. There are just many reasons we don't need to talk about that in a public forum. So I appreciate not going into detail on that topic.
I withdraw my question.
Okay, the last two items were on the escalator, the reported incidents for the year 2023. There was a total of 11, and in 2024, there was 12. On the elevator, the year 2023, the total was 6. In 2024, there were 10. And we have implemented a seminar to make sure that all the inspectors are familiar with all the guidelines in their processing of these inspections, and that they follow the A17.2 guidelines. So each inspector looks at the equipment in the same manner. So we don't have one inspector that looks at the equipment based on his experience in the past, and a new inspector is following the guidelines that we require. We have quite a few inspectors that, because they've been doing this for such a long time, they have a procedure that they follow. However, to get everyone on the same page, we have to encourage everybody to follow the A17.2 guidelines. That way, regardless of what inspector is doing the witnessing, they'll be doing it based on the guidelines that I'm referring to on A17.2.
This is Sheila Sweat. I had my hand up, but I can't determine if you are seeing it. The A17.2, again, guidelines. I question a lot of the issues that you're wondering about. I know personally, I do legal cases also. But in the A17.2, it says in order to inspect an escalator, you must remove half of the steps.
Are you saying A7?
I'm sorry, what? Half.
No.
No. Normally, when they do a clean down, it's either done annually or every 3 years, depending on what manufacturer. They will take out half of the steps so they can examine the truss below the steps, examine the chains, examine the rollers. They look for cracks in the steps. And in order to do that, they have to remove half the steps so they can clear that entire truss area from the top to the bottom. When they do an annual inspection, If the inspector wants to look at something that he cannot see from the lower end or the upper end, then they would have to remove anywhere from 4 to 6 steps. So it'll clear the lower end or the upper end so you can see directly down below the steps at the pit area at the bottom and at the machine room area at the top. But that's gonna be up to the inspector. If he sees something that doesn't seem right, he wants to examine it more closely, he'll have the mechanic and helper remove those steps. But it depends on the type of unit, like say for Montgomery or Kone, their motors are mounted truss. Otis has their machine at the top, and Thyssen has theirs at the top. So depending on what they want to look at, like they want to look at the brake torque on that motor on the Montgomery Kone, then they're going to have to remove steps. Some inspectors will only have them remove 2 steps to 4 steps so they can see the motor, or they can see below the motor where it's mounted in a truss.
Yes, sir, I understand that. But someone was saying to utilize those guidelines strictly as in part of the code, and it does not delineate whether half the steps must be removed. It says on inspection. Now, it is not being done on inspection. The 4 plus or minus is being done. And half the steps is totally unreasonable due to the physical location of storage and everything else. My issue is when you say shall be used, shall being a has no other than, then you're actually putting it as a code. And as you described, escalators are different, elevators are different, also different places. And the inspector must have the ability to advise what they need and not what just that code says, because there's some things that the guidelines do not accurately protect us against. We've got to have knowledge of the actual elevators and escalators. I'm sorry. Thank you.
Chris Flannery, General Counsel. It sounds like this issue that y'all are discussing is an important one. What I would suggest is that we table discussion for it for right now and bringing it up at the end of the meeting to add as an agenda item for future discussion, possibly for an assignment to a work group to look into. Sounds like modifying what Board Member Sweat interprets as kind of a burdensome requirement in order to complete an inspection. And that's something that we as the department need y'all's professional experience in order to determine. So if I may, I'd just like to ask that we table discussion for now, bring it back up at the end, and make sure that we talk about it at our next meeting after the work group talks about it. Thank you.
Grayson Gill speaking. Thanks, Chris. Appreciate it. Good advice. Edmund, anything else you want to add?
Mr. Chairman, Brian Morris, I have a question.
Yes, sir.
So on the, again, I'm gonna keep saying this apparently, but a reference from 6 years ago. What is the current time period to get a plan review done? Because when it first got kicked off 6 years ago, the plan review period was honestly, Jim was doing it in a couple of days.
Can you give us 1 minute, please? 1 minute.
Mr. Gill, just wanted to let you know that Miss Cynthia Marple is her audio has been corrected, so she is ready to give when you're ready for it.
Thank you, sir. Once we get done with Edmund's group, we'll circle back around there.
Oh, Edmund, I think you can continue with your presentation if you have anything remaining.
Okay. Can you hear me now?
Yes.
Okay. Currently, we have several projects that we're working on. One of the projects is that when we have new inspectors that have applied and we have a orientation where we discuss, you know, the reasons why they want to become an inspector and what their experience, their background is, we decided we wanted to have a face-to-face communication with them so we could see the inspector and they can see us. We can introduce our staff to them so they know who these people are. And it gives us more of a personal relationship with these new inspectors because we wanted to emphasize the following the guidelines that I referenced earlier, the A17.2. So everybody is doing inspections in the same manner. And in the past, we were only having an orientation, but without having the visual ability to see the inspector and be able to ask them more in-depth questions about their experiences in the past and what their intentions are to be an inspector. Some of the inspectors are working for elevator inspection companies. Other inspectors are individuals that they work for themselves. So we just wanted to get a better idea of who is going to become a new inspector and how familiar they are with this new job that they're undertaking. One of the other items that we're implementing is a seminar that all inspectors are required to attend. And that seminar will be provided on a monthly basis. And they have to attend one seminar per year. The information provided is going to include all the processes and procedures from the forms that they have to fill out, where they send them. Also, when they first arrive on a job to do the inspection, how they meet with the customer, identify themselves, and meet with the individuals that are going to be performing the test. So all these procedures for plan review, waiver, delay, alterations, new installation alterations, all of that would be covered in this seminar. And then the final part of the seminar is going to be involving safety procedures that we feel are the most important part of their jobs because it's protecting the riding public. And this part is very important because of the situations that have come up recently, the incidents and accidents. We just want to emphasize that, you know, the riding public receives the finished product that the elevator is safe. But also the sorry, just one moment. But also the inspectors, the mechanics, helpers, the people that are actually looking at these elevators and escalators prior to them being turned over to the customer, they are in harm's way at times because sometimes the equipment is not working properly or it's not adjusted properly. So they're exposed to this before it ever reaches the riding public. And our emphasis is the safety of everyone involved in doing the inspections. And the final is the riding public. But there's so many times that a lot of inspectors are older. And statistics indicate that the longer you're working in the elevator industry, the more likely you're going to be involved in some kind of accident. Because the mechanics, the inspectors, they become a little complacent. Things that they used to do without fail, they forget about that and they make mistakes. And unfortunately, no, if I make a mistake on a report and I have to correct my report, that's one thing. If you're an inspector or a field mechanic and you make a mistake and you don't check to make sure that top of car inspection circuit is working properly, and you step on the car and the elevator takes off, but you didn't verify that top of car inspection station was not functioning properly, then you could become injured or worse. So we really are pushing safety is our number one priority for the inspectors. And in the process of doing their inspections, they can't afford to make those kind of mistakes. So that's the one thing that we try to emphasize at the end of our seminar is the safety for everyone. Because after all, these inspectors, at some point in time, they will ride these elevators and escalators. Their families may ride them, the grandkids. So it's so important for all of us to make sure that we work in a safe manner.
Grayson Gill speaking. Thanks, Edmund. Anything else you got for your report?
I think that is all I have at this point. So if there's any questions that you want to ask me, please feel free to.
Great, thanks. Back to you. This is Grayson Gill speaking again. Back to you, Brian. Did you feel like you got your answer to your question, Brian Morris?
No, I did not. Again, this is Brian Morris. Thank you, Grayson. So on the plan review, how long is it? How many days does it take to get a plan review completed currently?
Hello, Mr. Morris. My name is Rudy Sharfat. I actually do the plan review, so I'll be happy to help you with that. Plan review completion date. Normally, we have two options that we offer the contractors, beginning with the expedited. That is completed anywhere from about 1 to 5 business days of my receiving the plan review from the revenue team and admin staff. And we also have the general standard plan reviews that, due to the high volume, that's the completion days, about 10 business days, but overall about 4 to 6 weeks from the whole process due to the high volume. Did that answer your question, sir?
Okay, I think a little bit, so you were breaking up a little bit. So you're saying it's 4 to 6 weeks for a standard plan review?
Correct. And
Okay.
5 business days approximately for an expedited payment.
Okay. All right. And again, the volume has gone up quite a bit. And so whenever we first came up with that rule, I don't remember if there was some language in there about how soon it would be done, should be done. But I guess at this point, that's what the industry is given. I guess I have another question for the board. Would it be any value for us to see as part of the reporting here is the new technology variances? If there are variances throughout the various fiscal years, or that it's so small and minor that it's not a stat that the board would like to see on these compliance reports.
And I'm sorry, Chris Butterbrook, General Counsel. It sounds just like the issue that you just brought up in terms of plan reviews and the timeliness thereof is something that is created by a rule that you feel may be necessitating review. Is that correct?
No, sir. No, I'm just again whenever. Because like I said, us older legacy, I mean, we created this stuff 6 years ago. It didn't exist. The plan review, we went through all the meetings and all the language to adopt and add all the administrative rules for that. And I know that early on, there was some language in there talking about a time period of when plan reviews would be expected to be done. And then we also did have the expedited deal. And I just don't remember what that language was. But obviously business is booming, so it takes it without adding more staff, it takes time to get plan reviews done. So I was just curious where we're at currently.
Thank you. Appreciate you.
Okay. Then again, back to the board, is there any, thought to have staff include the new technology variance reports as part of compliance? Okay, I'll take silence as a no. That's fine.
No, I was going to wait for everybody else to speak. This is Grayson Gill speaking. Brian, I agree. If we can get the staff to provide that to us, that might be information that we can use. So if it's not too onerous, that would be great.
I appreciate it. Alex, is that your charge?
Okay, this is Sheila Sweat again. I'm normally going to be your pain.
No, you're welcome.
There are times when these, and I'm not extremely informed on when plan reviews are required other than new equipment and possibly modernization. But if they're required on other pieces of equipment that are being replaced because they are damaged and therefore they are, there are problems with a customer being without an elevator, and say that happens to be in extreme circumstances like a medical facility or something like that, 10 weeks, you can put a whole new elevator in 10 weeks. And it's not that there's no other job in this world that I know about that I would least like to have than plan review on elevators. It changes at a drop of the hat, and you have to be extremely educated in those reviews. But still, 10 weeks for a plan review, sometimes the customer has not even signed the contract 10 weeks from the plan review. So, or from when they are expected to be on site to repair or replace a piece of equipment. And I'll try to be better next time.
So this is Jerry Matheny, and I've had conversations with Edmund, Rudy, Elisa about this particular subject. And as a contractor in the state of Texas, and I operate in a different state with a different set of rules, we have adopted the following because we know how long it takes when we get a signed contract from a customer. The first thing we do is apply for a plan review. That's how we have accommodated for going from a week when I started doing them 12 years ago to now 4 to 5 to 6 weeks. So that's what we've had to do, and we're agile, and that's how we accommodate for it. They're pretty consistent at TDLR about turning them over in 5 to 6 weeks, and when they don't, I send an email to Rudy. and want to know where my plan review is on a stack, because as you guys know, we also have to be agile with our customer, because sometimes we're talking about a single conveyance in a building. And if that conveyance is out of service, so one of the things that I would like to discuss about the plan review is not an economic issue with a expedited. I would like to have an emergency plan review without an economic impact, because that is truly customer service. And if it costs $800 to get it in a week instead of 5 weeks, I think that we need to revisit that. Now listen, I don't pay it; the customer pays it. So, but I'm an advocate for our customer, and I'd like to. I guess that would be new business down the road. The attorneys on my bottom right. I guess that would be new business for something. But I also talked to Sheila and Edmund about having a some type of meeting quarterly where they invite inspectors and contractors to Austin to sit around and talk about how we can improve all of these processes. Now, I don't know if that's possible, but without input, you don't know what's happening. And I got a lot of input, and you can ask Sheila and Edmund about that. So I know that's probably new business. I'm the guy that out in the trenches here every day, having to deal with the customers, and I'm the bridge between them and TDLR. And I have, in my opinion, a high value of information, and that's not being provided to TDLR. And I would drive to Austin from San Antonio once a quarter, and we could sit down for the day and talk about the things that we come across as contractors. And I do have a lot of things to talk about inspections, but as a contractor, you need to understand, first of all, I'm going to give you a contrast. I work in a different jurisdiction, and the number of elevators to the number of inspectors is much higher in that jurisdiction than they are in Texas. Way higher. I work in a jurisdiction. Go ahead.
Oh, I'm sorry. I'm sorry to interrupt. We may be getting into new business, and I think everything that you're saying is valid. Can we add this to the agenda? Can we add this discussion to the agenda items for our next? Discussion?
Christopher, I don't have a problem with that, but we need to meet more than every 5 years to talk about it. Then.
Oh, yeah. No, it's. I think that's universal. Yeah.
Okay.
So we'll go ahead and I'll add an agenda item for discussion. Well, we'll talk about it when we get there. I just don't want to create too much new input, but it sounds like it's very valuable input. Thank you.
Mr. Chairman, Brian Morris again. So Christopher, this was not a walking quorum. I had no previous discussion about the permit, so I didn't know what hornet's nest I was stirring up or asking, but I guess I'm glad I did. And like I said, back to the early days when this first got kicked off, yeah, plan reviews were done in a week. And Jim, worked very hard in keeping up with it in 2018, 2019, pre-COVID and stuff. But yeah, business is booming in Texas, so inspections take times. So
without disclosing too much, what's going on here, I'll just say that everything that we've been discussing is being discussed internally, and your concerns are shared by the department, and where the length of time between board meetings is going to be drastically reduced. So we're going to be receiving more regular input from all of y'all on a variety of topics. But again, the public needs notice that we're going to need to start talking about new business, and the best way to do that is to put that on the agenda item or put it in a work group and then talk about it next time, which we'll try to make it as soon as possible.
Rudy Sharp here, plan reviewer. I just want to piggyback on what Mr. McKinney was saying. And he, truth be told, all plan reviews are completed maximum time 10 to 15 days. All plan reviews. The whole point of the 4 to 6 weeks has to do with more so it's a document matter with the contractor's contact person giving the misinformation, or contractors do not have the proper funding or proper information, not licensed at the time they submit a plan review, so which could lead to some haltage at either the revenue team, admin, or myself once I get it. That is the main factor why the 4 to 6 weeks hold us back, and also the large increase of volume due to construction alteration that's being done in the past 6 years. Now, with regard to our staffing and myself, how do I handle the plan reviews? The information we require is pretty simple. Once we get it, we work hand in hand with the revenue team to notify us of expedited plan reviews, which take priority due to the cost and the urgency of the request from the contractor. But overall, all plan reviews are completed from anywhere from 5 to 15 minutes. That's pretty much our turnaround time, and that's captured by our business analysts for auditing purposes. So it's not an issue, and Mr. McKinney can attest to that, as I have worked hand in hand with them to give him information he needs on emails. So that's that on our end.
So I'm just going to make one more comment about the plan reviews. Another thing that we've had to adopt in my company, I can't speak for other companies, but there's something that we saw that was inconsistent when we mailed through the Postal Service to Austin. There was some kind of disconnect there. I don't know what's going on in the mailroom. We didn't know. So every plan review we send to TDLR now is overnighted Federal Express, so we know that it's arrived. So there's things that we've had to adopt. And like I said, we need to sit around and talk about this. And Christopher, I can appreciate that you guys are having conversation, but without us, I don't know how you're having those conversations. Thank you very much.
That is not that's a mailing issue that we may have to address, but that is not with the processing of plan review as far as like the review process. Yeah.
No. I understand that, but once it leaves my office, with all due respect, it says it's addressed to TDLR on that envelope. Now, when you send it to Ameritex, we get something in Ameritex. We have different departments ourselves, but we make sure that the processors are in place to take care of it. And I just listen. If you don't want me to highlight what's going on as a contractor, I'll keep my mouth shut. But I'm here. I love this industry. It's my 43rd year in the elevator industry, and I see things that need to be done. I'm going to bring them up.
And Board Member Massey, I just wanted to be clear. What part of the reasons that we're doing these more regular meetings is because to form more groups, because that's how we communicate with, actual industry professionals such as yourselves to gather the feedback that we need to craft like our own responses to them. Yeah, we really can't do this without you. And so, no, we don't want your silence. We want your cooperation. And so that's that's why we've called this meeting, and that's why we'll be calling more meetings in the future.
Great. Grayson Gill speaking. All right, Edmund, anything else on compliance before we move on?
No, I don't have anything else.
Thank you very much. I appreciate that. Brandy, if you'll stand by just a second, we're going to circle back to Cynthia now that she's gotten her audio figured out, and we'll come back to you in just a second. So go back to enforcement. So Cynthia, you have the floor.
All right, I hope you can hear me much better now. Is this better?
Yes, thank you.
Okay, great. Okay. Marple again. So I think I was at the point where I was starting to talk about the performance measures. So you see at the top here, the performance measures. We do report these to the legislature. And as you can see, they're basically consistent between the two fiscal years. We do have an increase in complaints being processed, and that could be due to now having 3 instead of 2 persons designated in intake to handle incoming complaints. And the percentage of cases closed has gone up a little bit in the last 6 months from 57 to 60. And the amount of days it takes to close a case has gone down a little bit, which is another positive change. And if you look at the criminal history review section, as you can see, no licenses were denied or revoked based on past criminal history for the inspector and the licensee pool for elevators. And then on page 2, I like to look at the pie charts instead of what you see at the bottom of page 1. I think this is a better illustration of where our sources of complaints are. And as you can see, we're unique. We have virtually no criminal history right now. So it's mainly departmental complaints, and then a smaller percentage come in from consumers. And I think a lot of departmental complaints stem from inspectors, what inspectors find, because they're doing their jobs. And as you can see under penalties and remedies, if you go down, our caseloads are fairly consistent. And the penalties and remedies will show you how many fines have been assessed and how many have been collected. If we have payment plans or started a default process, that would explain why the penalties collected are not exactly the same as the penalties assessed, plus the timing of when the report is issued. And again, we have had very little, no disciplinary sanctions actually for the elevator licensees. And then going down to page 3, we have our cases closed without disciplinary action, which is where enforcement can really shine, because we do strive for compliance. Our goal is to make sure all the elevators are inspected, because I'm sure you can agree that you need those inspections to ensure the safety of elevators, escalators, and the other related equipment. You want to catch it before it breaks and before something happens. So oftentimes, if a licensee or a building owner has come into compliance voluntarily, we will close it as informally resolved. Also, when an inspector does it, and our inspectors do inspections of complaints, sometimes there is not sufficient evidence for violation. So as you can see, we do have a high percentage, but we close without disciplinary action. So we give, building owners and licensees the opportunity to learn and make corrective actions. And then you'll see our top allegations at opening. As you can see, one for both top allegations and opening, and then a little lower, the violations resulting in disciplinary action, failed to inspect the equipment annually. As I stated earlier, an uninspected elevator is an unsafe elevator. So that's the way to catch issues before they become something major. Those are the primary disciplinary actions that we take. And then on the last page, you'll see 2 case summaries for your review. And I also wanted to provide an update on a project that enforcement has been working on that the Sunset Commission recommended during our last sunset review. And so the Enforcement Division has completed a review of each of the elevator's most frequent violations to identify and prioritize those that pose the greatest risk of consumer harm or potential physical injury. And so the goal is to focus our limited resources on the complaints that have the greatest impact on public health and safety in the most efficient way. That was something Sunset gave to TDLR as a whole for all of its programs. And there's more detailed information in your packet, but we have now completed our review and prioritization of the different types of complaints we receive so that we can, again, get to the ones that could cause the greatest threat of harm first. Thank you for your attention, and please let me know if you have any questions.
Grayson Gill speaking. Cynthia, could you page back up one page? Okay, go down a little bit. Under alleged violation, the last item, failed was made into a life without giving department notice. What is that?
I think that is probably I'm not sure off the top of my head. I think that was from 2023.
No, I'm just saying, what's the, I don't understand the category, not the number of the item.
No, I understand, and you're right that I'm not sure if that's a typographical error that I missed.
Gotta be. It's gotta be a typo. I don't understand what that is. Anyway, just check into that. I appreciate it.
I will look into that and come back to you.
No problem.
And I apologize if I'm okay.
No worries. Thank you. Any questions for Cynthia before we move on? Great. Thank you very much. Appreciate it.
Thank you.
You bet. Okay, back to executive office. Brandy, we're coming back.
Good morning. Good morning, presiding officer and board members and TDLR staff. My name is Brandy Myers. I am the Deputy Executive Director over Administrative Services for TDLR. Since this group last met, we have a completely new executive office. And so I want to kind of just give you a highlight on who those folks are that are now in leadership positions of the agency. So first, I want to let you know that our new permanent executive director is Miss Courtney Arbor. She was the workforce development director at the Texas Workforce Commission before she came to TDLR. She joined us on June 1st of this year. So she's not brand baby new, but she's relatively new to the agency. She's excited to work with all the different programs and excited to be here. And she has been a treat to work with. Next, I want to let you know about Mr. Steve Bruno. He is the Deputy Executive Director over our licensing services. So his area of responsibility in the agency is over licensing, customer service, and the education and examination divisions. You may recognize his name. He has been with TDLR for a little bit. He was a government relations officer and also our legislative director before becoming the Deputy Executive Director almost a year ago. And then we have Miss Susanna Holtz-Catrone, and she is brand baby new to our agency. She just started actually a week ago on October 1st, and we're excited to have her as well. She is over the regulatory services divisions of our agency. So that includes enforcement, field inspections, and compliance. She is also joining us from the Texas Workforce Commission, where she was the Deputy General Counsel. So she is also here. And lastly, my name is Brandy Myers. As I said, I am the Deputy Executive Director over Administration. I've been with the agency for about a little over 5 years. I came in as the agency's Chief Financial Officer and took this role almost a year ago as well. And my areas of responsibility is all of our indirect administration, such as financial services, Office of Strategic Communications, IT, information security, contracts, procurement, like I said, all of our indirect services. So that is what the executive office now looks like. All of us are very excited to be in our positions. All of us are very excited to be working with our board members. As you have heard through conversation today, the boards will be meeting more frequently than they have in the past. So we are looking forward to having your expertise and input on things that are impacting your industry as we move forward. And I am happy to answer any questions. Thank you for your time.
Grayson Gill speaking. Thanks, Brandy. Any questions for Brandy? All right, did we miss anybody? Any other staff reports?
No, sir, that should be it.
Okay, great. All right, moving on to the next item, discussing our work groups and tasks. And obviously, since we talked about, we haven't met in a long time. And I didn't know, Alex, could you and the team kind of go through the work groups that we had previously and any background that you can give on us and what those topics were, any progress that was made, so we're not starting from scratch. And Brian Morris, feel free to chime in as well, since you were principally involved with assigning a lot of those. Let's try to get everybody up to speed so we can make up for lost time and pick up where we left off. Alex?
Sure, thank you. Let me bring up the work group that we had. This is a list from 2015.
Get out if I can.
Okay, is everybody seeing this? This is what we had. It's just a list of the work groups that we had. Looks like between 2012 and 2015. The categories for this one were continuing education, defined experience, and fees. Since then, we have reconfigured the categories, and I'll go ahead and put that up. Go ahead and share that. I apologize, that's the wrong one. 1 second. Okay. All right, so these are the new categories that we have for work groups. And the categories here are by the divisions. There's enforcement work group, licensing work group, education and examination work group, and standard of care work group. And as you can see here, we have some brief explanation on what those entail. As you can see, the enforcement work group is to review and make the recommendations regarding criminal conviction guidelines, the penalty matrix, and other enforcement related matters and rules. The licensing is to review and make recommendations regarding licensing requirements and rules, inspections and compliance, and other administrative matters. Education and examination work group will review and make recommendations regarding education and examination, continuing education requirements, and rules. And then the standard of care work group will review and make recommendations regarding the standard of care matters and rules. So these are the 4 that we have them broken up for that.
Great. Just thinking of Grayson Gill speaking, just thinking about this, Brian, any thoughts from a historical perspective from what you and the team had led us through several years back.
Sure. Again, Brian Morris. Okay. Here's my history of TDLR. Several of these work groups I don't know where this came from or if staff created this, but several of these are foreign to me. I just don't recall any issues with the standard of care work group or what that was for. The education examination work group, again, that was, I think, created and formed because the continuing education was a new requirement 6 years ago. If that's all matured and there's no issues with it, I don't know if that's a work group requirement or necessary. I can go back through, again, if TDLR doesn't seem to have a lot of good history, I can go back through my notes here about some of the previous work groups. I honestly, Grace, I'm glad you're chairman because I'm not really sure how to go forward from this or what work groups are needed right now.
Well, Grayson Gill speaking, I mean, that's what we're here to talk about today. This is an open discussion. And I think that the topics we were talking about before, whatever is an issue that's a challenge for us in the industry, I think we should have a work group around it. I don't know that we necessarily want to structure the work groups around what's right for TDLR organizationally. I think it needs to be around what are the problems and what are the issues. And then as we find out what those are, and we then can go through and determine what, as a board, what areas need to be addressed in order to deal with those problems, we can work through that. Chris, you've got your hand raised. Go ahead.
Thank you. These are categories: enforcement, licensing, education, examination, standard of care work groups. These are the categories of work groups that we pretty much apply across the board to all advisory boards. Generally, any issue that a board, no matter the profession, is going to be wanting to investigate further, we can fit it within one of those categories. So, for example, Ms. Sweat brought up earlier the issue of A17.2, like removing half the steps from an escalator is an unreasonable step for inspection. And that could probably fit under the standard of care work group, potentially the licensing work group, or just in general. Honestly, I think it would probably be under standard of care because that would be go to the heart of what it means to perform an inspection. So with the current set of issues that we've been discussing today, I think we can find a home for them in one of these categories. Now, as far as the historical work groups that they have done their work, I guess my first question is, and it sounds like this one's already been raised, are they still relevant?
How's it going? Did you? I know. I was all thinking. I wonder. I don't know if they took away the phone or not.
Again, Brian Morris. I'm not sure if they're still relevant. I honestly, I don't remember what they were.
My temptation is to just start fresh, right, and start with the current crop of issues that has been brought up within this board meeting. It sounds like there was some. It sounds like there was a continuing education bottleneck that may need to be discussed. I think I said there were 3 providers available. I mean, that may be an issue that we want to look into. Do we need to expand the scope of available continuing education providers, or is there a need for that? But again, I think whatever issues that we have that this board may want to address, we can find a home for them in one of these 4 categories, and then maybe supplement the new discussion with the documentation that already exists. Again, this is just a proposal, but I wanted to float that, see if that was something that you'd be interested in. And it looks like Brandy's raised her hand.
Hi, Brandy Myers, Deputy Executive Director. I just want to add that these have been work groups that we have uniformly named, I think, as Mr. Funderburg mentioned. They can be named anything we want, but these are just the standards that we have used. Like you said, most things fall into one of these categories, and our goal is to have folks appointed to these work groups so that when something comes up, we've got a go-to group and we don't have to convene another meeting just to assign that work group in order to help solve research and look at these issues. So that's kind of our goal for what we're looking for in filling these work groups at this point in time. If you prefer a different name for the work group, we can do that. Again, this has just kind of been our standard, is what we've been seeing works primarily across the rest of our advisory boards as well. Thank you.
Thank you, Becky.
Grayson Gill. So just by example, we talked about expediting plan review. Where would you put that?
I would probably put that under a licensing work group, or the compliance division, which would probably be under a standard of care. But again, I think it's more the TDLR personnel that's assigned to it, in addition to the board members, that is really going to get the synergy that we need to reach fruitful discussion. Right. The titles we can modify; that they're not set in stone. But it's really the personnel who's assigned to it that's going to, generate the beneficial result.
Grayson Gill. So, okay, what we'll do is, obviously y'all are trying to keep not only the elevator board, but all the other boards on some type of, even keel in terms of terminology. Why don't we just agree to do this? We're going to bring up the topics that we're passionate about, that we want to talk about, and then y'all can decide what category you want to put them in, if that's okay with the group.
And I don't see a problem with that. It may, because the board members are going to have to be assigned to these work groups. If you're the presiding officer decides the work group assignments. So if there's a particular topic that you would prefer a particular board member be involved with, you just would want to make sure that that board member gets assigned to the work group that is ultimately assigned to the task that that you're passionate about.
Gotcha. Grayson Gill speaking. What about other comments from everybody? Would that work for everyone? If you can kind of give an example and then decide where it would fall, then that would help you with your decision on which group you want to sign up for.
Again, Brian Morris. Yeah, I think I agree with that. So yeah, like Grayson said, we throw out the topic and TDLR tells us where to put it. Then once all of these issues are slotted somewhere, then I suggest we do the assignments after that.
Yeah, and Chris Funderburg, just to clarify, the presiding officer decides the work group assignment. Once we assign the members, and then we can assign the topics but really it's in the presiding officer's discretion. Like this is kind of your ball game.
But again, I assume that the presiding officer would allow us to volunteer for the work groups if we're passionate about them, because we don't know what's fallen into which work group.
Right. Exactly. Grayson Gill speaking. Exactly. So
thank you, Grayson.
I think as we talked about before, we're gonna tell you what are those topics. You tell us which category they are, and then that person can then volunteer for that category.
I like that approach, Grayson. Wonderful. Permit review. Where does it go?
I'm sorry, which one?
Plan review. TDLR tells us the hot topic is plan review. Where is TDLR slotted in? Which one of these 4 work groups would TDLR want it slotted into?
Chris Funderburg, and I'd ask, could I ask compliance to weigh in on that one?
Yes, we were thinking probably that would land underneath the standards of care, since it's dealing with a rule to review it.
Okay, Grayson Gill speaking. So if we put plan review under standard of care, what board members would like to be on that work group.
I'm sorry, Grayson, could we figure out all of the hot topics first? Where
Sure.
they go?
Absolutely.
So I think Sheila, the next one was the inspection. How would you state that?
Have to find the unmute button. What about the inspection? I mean, there's the
Well, I'm sorry. I assume that you're talking about the practical application or the black and white per TR rules versus the standard application or whatever that issue is about. So describe
yes,
that so TLR knows where category to put it in.
yes. Inspection rules and requirements is actually what's required. As also workshops, but you're discussing having more communication. There's really no communication. And I don't know that my name needs to go in there because this is my last year, and I was put in 6 years ago, and there hasn't been a meeting in 6 years. So I'm sure that it's going to be, I can't be involved in a group that does not meet because then I can be blamed for the things that they do not do. So, you know, that's all I'm saying. This is the last year of my realm of 2-3 year periods. And this is also the very first time I've been in a meeting. And I've called and texted many times asking if there's meetings that I've missed. Do you have my email wrong? Da, 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 da. And it's no, we'll contact you.
Yeah.
So
Sheila, Grayson Gill speaking. Sheila, we understand. Okay, so back to the TDLR, what of these work groups, where would we put issues that come up around compliance with those requirements of any of the testing or verification steps that happen at the testing at the
I think education and examination work group, it might fit better in that.
Grayson Gill speaking. Let's let them decide what category. Let's just define it so we can.
Education of inspectors to what is required by the state of Texas, period.
Grayson Gill speaking. Okay, from TLR's perspective, which work group would that fit in?
Oh, Chris Thunderberg. Again, I'm gonna have to think it should defer to compliance on this one.
Yeah, we're waiting for them to talk.
Right.
Yeah, we're thinking that it's more standards of care since it's talking about getting into compliance.
I can agree to that.
Why would it not fall, the Grayson Gill speaking, why would it not fall in licensing work group?
Because there's another license. This is Delisa Hamilton, I'm sorry, section manager for building safety section. Because it really doesn't fall underneath any of the licensing requirements and rules. As far as with the inspections and the compliance, that literally goes with like the elevator inspections because those forms have to go up to them, which is what they collect. And when you're talking about just the standard of care, because if you look underneath the standard of care in the elevator rules and the laws, it actually pretty much is about ethics, dealing with them not adhering to that. So that's why we are saying a standard of care work group, that it will fall underneath that.
It's gonna fall under 74.
Mhm.
They adopted.
Well, Grayson Gill speaking again. So just as a heads up to the TDLR team, you're going to have everybody, if you keep putting everything in their standard of care work group, you're going to have everybody in standard of care work group and nobody in the other work group. So let's think about how we're going to split this up as we bring these topics up. So you may, Grayson Gilligan, you may want to think about the fact that inspections and compliance and other administrative matters could actually apply to both of these topics that you've put into standard of care work group.
Chris Thunderbrook, we're discussing since our subject matter experts in compliance, we kind of followed their lead on technical things. I think the one topic that I know was brought up earlier was the possibility of having an emergency inspection on an expedited basis. I'll ask compliance for their input on that, but.
I'm sorry, again, this is Brian Morris. I believe we were talking about emergency plan review.
Or, excuse me, emergency plan.
Plan review, yes.
Plan review, yeah, thank you.
Okay, Grayson, yeah, I think we're all, the board, the board wants the inspection rules under licensing group. TDLR in-house can figure out who to assign to it.
Okay.
Because again, Grayson, you're so wise here because I was going to the same thing. Everybody's going to want to jump in on the same group, and we can't do that because then we would have a quorum. So those two hot topics right now need to be in separate work groups just so we can have spread out our board members.
Agreed.
Yeah, thank you. Did I put words in your mouth, Grayson?
No, that's fine. Okay, so to the TDLR team, we'll assign the board members to just two work groups right now. It's basically what we're going to have. Right?
Yeah, it sounds like they're right. And then as long as we don't hit the threshold of a quorum, we can assign up to that amount. And then at the next agenda, we'll probably we'll coordinate with the board, with the work group, have them meet, and then hopefully we'll generate enough of a work product that we can present it at our next elevator meeting and place that as an agenda item so the entire board can hear about it.
Great. Thanks, Chris. Grayson Gill again. So another topic to figure out what category goes in. Brian Morris had asked a question about the fact that we've got so much more construction and so much more backlog in terms of plan review. The stats bore that out. If you look at 23 to 24, do we need to have a group looking at how do we recruit more inspectors to these inspections? If you've got new installations spiking, then that means we're going to have a further pipeline issue down the road on inspections as those mature. So do we need to have a work group focused on how can we try to recruit and increase the number of inspectors? I think that we had one comment, there was another jurisdiction that had a much different ratio. It might be helpful for the staff to be able to come back and tell us, where does Texas stand compared to other states in terms of inspectors to equipment, or some metric that we can look at to see where we are. So that would be a topic I think we need to look at, is trying to get ahead of the growth and the continued growth we think we'll have in Texas.
And this is Chris Thunderbrook. One, this bottleneck has arisen in other professions regulated by TDLR, and it's been proposed in some of these professions that the bottleneck is due to the licensing standards that are in place that are an impediment to more licensees becoming licensed. I don't know if that is something that you want to explore.
Grayson Gill, I wouldn't imagine that anyone would want to reduce the standards. I think what we've got to do is recognize that we're in a growth spurt in Texas that will continue for a long time. This is not a short-term issue that we can work around. We've got an incredible amount of people moving here. We've got an incredible amount of development going on.
Right.
And so I think what we've got to do is work on trying to figure out how to recruit, attract, and educate them. I doubt that we're going to need to look at the education requirements. No one's going to want to reduce them.
Okay. I don't think there are any other professions that were talking about reducing them, but maybe expanding the availability of them. But if your concern is that this would mean a watering down of an experience that is mandatory for these type of sections and installations, then it would probably be assigned to a different work group category.
Well, I was
Mr.
just trying to get another item to maybe fit into maybe education and examination. So looking at those requirements and looking how to increase our recruitment.
Mr. Gill, I just want to let you know that Ms. Sweat had her hand raised.
I merely have a question. Does anybody know how many devices there are in the great state of Texas? No.
Hi, Yvonne Lopez. Let me pull up my report
Over
again.
under 38,000.
Yeah, the population is showing about 38,000. We are looking into some of those metrics to validate the accuracy of the numbers. But as it stands, the population for the equipment is a little over 38,000.
Okay, that is what I wrote down as we were going through it. I just wanted to make sure. I divided that by the number of inspectors there are, which is 206 devices, which is normally 206 inspections per inspector per year, which comes out to 4 inspections a week. Either we have inspectors that just want this on their resume, or they are not actively working.
Hi, this is Jerry Matheny. As a contractor speaking again, I don't see an issue with the number of inspectors. I got them banging on my door every week for business. Okay, so that's not an issue. I do have a question regarding all of this, and since we're talking about this, I'd like to know, I have a question that how many people are existing currently in TDLR elevator unit? From Edmond on down to plan review, how many people are there in that group?
We currently have 5 staff members.
Okay.
And that is in compliance. In licensing, we have 13 staff assigned to that program to process elevator inspections. But as I said earlier, the entire licensing division is processing elevator inspections. We're mailing out test tags, decals.
Now, I just want to talk about the safety aspect of it. I understand the paperwork side. I don't want to talk about that.
Okay.
So we have 5 people. How many of those people are licensed inspectors?
We have 2 of them.
2. So we have 38,000 conveyances in the state of Texas. We have 180 plus inspectors, and there's no policing of the inspectors. And what I've recommended, what I'd like to recommend, is that we increase the staff to at least 4 more inspectors that don't work in the office and they go out and spot check inspections throughout the state of Texas. That's going to clean a lot of things up out there, because from a elevator contractor, I am called on a daily basis to go look at elevators that are either not functioning correctly. And I look at the elevator, I look at the reports, and I see multiple years of the same violations, and something has to be done about that too. So if we're going to do inspections and we're going to have violations, we have to address the violations, because my opinion is if we don't, what are we doing it for?
Grayson Gill speaking. Sounds like a great topic that we could potentially put into enforcement work group. If we need additional enforcement, then maybe there's a subcommittee group that can work on that.
So I have one more thing I'd like to bring up to the group, and I don't know where you can put this, and I know there's been a lot of debate about this in the past, but I would like to put in there licensing for elevator technicians. I don't know how the union stands on that. I don't know how the non-union people stand on it. And different jurisdictions, when there's violations, they're signed off by the technician that completed the work, and therefore the authority having jurisdiction knows that work has been completed. So I'd like to put that in one of the categories as well. I know that it's been debated in the past. I just don't think the debate has been healthy enough to make that happen.
And I don't want to speak out of turn, Chris Funderburg, but it sounds like that would be a good candidate for the licensing work group.
And I have, excuse me, this is Jerry Matheny one more time. And Edmund, please forgive me for what I'm about to tell you, but I've been to safety meetings with the union and all of the companies, and that subject came up about, you know, the elevator guys are getting older. Well, I hate to tell you this, but ever since I've been in the elevator trade, we've had old elevator guys, okay? That's not the issue. The issue is what I'm about to tell you is the issue. For about the last 25 years, elevator companies have been ramping up the number of units that is a responsibility of the service technician, and he's running around with his hair on fire, getting to work on elevators that, first of all, he's had no education on, and the average route size in the industry right now is more than 250 elevators per technician. That's a safety issue, not the fact that these guys are old. I hate to say that, Edmund, but we have a different philosophy at Ameritex. We don't go over 75 units per route. So our guys work safe and they get to do their job. But when it comes to safety, the number of units, and there, by the way, there's nothing can be done about that because there's no elevator technicians to split those routes in half. So we have an industry issue. Plus, we're losing valuable people with years of experience as well to retirement stuff. But it's not an opinion. That's basically they just have too much work to do, and they're showing up and they don't even know what they're working on. So sorry about that, Edmund.
No problem. I understand what you're saying, and I agree with you completely. For the last 30 years, elevator manufacturers that have service routes for technicians, they have continually added to the routes. And like you say, that 250 is probably a little low, because I spoke with a couple of mechanics the other day, and they're carrying 275 units. And you're right, it can't be done, but they want to keep their level of profit by keeping the level of labor down. So, you know, there was a time when every elevator mechanic had this belief that he was going to do the best job he could. And it used to be the average size was about 60 to 65 units. But that has changed dramatically. And there is no way that a mechanic can be assigned that many units and go out and maintain them based on the manufacturer's recommendations in your maintenance control program. they have gone from having one visit per week or one visit every 2 weeks for a hydro to one visit every quarter. And then they assign that amount of time where it used to be 1 hour per unit. Now they've reduced it to 15 minutes per unit. So the indication that they give to me is that our program extends over several years. So we eventually will get to it, but that's not acceptable.
Chris, you got your hand raised.
Thank you. It sounds like, just based on their discussion, we've got 4 hot topics and 4 slots in the work group that they can be assigned to. I think it might be useful now if the deciding officer can poll the available members and decide where they would like to be assigned to these work groups. And then we can start on the TDLR's end, we can start setting up meetings with the work group so that we can, whatever decision it is that we're looking to reach, we can have those results available by the next board meeting.
Grayson Gill speaking. Perfect. Alex, why don't you just go around on a roll call basis and let's just see where everybody wants to fall on the work groups.
Yes, sir.
I'm sorry, Grayson, again, Brian Moore. So Chris, I guess I'm a little confused. I'm trying to take some notes here. So I guess Jerry's comment about possibly more staff, more QEI inspectors. Where are we saying that would fall under?
Probably the enforcement work group. We're talking about, it sounds like he was referring to an increased level of scrutiny at the inspection site.
Okay.
Hey, Brian, I'm sorry, this is Jerry Matheny. I was referring to increasing the staff for the elevator unit, not for the QEIs, not for the independent inspectors. I think we need more than 5 guys for the entire state of Texas, Brian. I'm sorry.
I agree. Yeah, I mean, I put QEI down because if you want somebody to go out to do some spot inspections, they need to be QEI. Correct? So if
That's correct.
Yeah. So if we want staff, so you're saying that the discussion would be to add more staff to the QEI department that are QEI inspectors to go around the state to do spot inspections.
That's correct.
Okay, so staff increase for under enforcement. Then under
so I want to mention one more thing too. I don't know if you guys realize this or not, but the authority that issues a QEI license, and there is a charge brought against one of their members that they issued a QEI license to, they also do their own independent inspection. I don't know if anybody on this call is aware of that, but there should be a side-by-side investigation of an allegation. I don't know if that's occurring with TDLR informing the licensing entity, but that needs to occur as well, because they do a side-by-side investigation. Because regardless of whether Texas will revoke a man's license, the authority issuing that license, for example, NESA, they may pull the license, and they should happen simultaneously, and that's in the code of conduct for NESA. I've held a QAI license. I don't do inspections in either authority I work under because that's a conflict of interest. I own an elevator company, but those investigations are supposed to be done simultaneously.
And when you discuss, Chris Hunterbreck, when you discuss investigations fall squarely under our enforcement division. So if you're talking about performing parallel investigations to certifying entities' own investigations, this would be an increase in enforcement staff.
No, it's done by the issuing company like NESA. They do their own investigation.
I was talking about the parallel to that, like the department parallel investigation that you're talking about. Like if we did one, we would have to, you'd want the certifying entity to know about it.
No, it's not, no, sir, not something, it's not what I want, it's what they do.
Right. This is Sheila, and I've had experience in this one because I went above city, state, and straight to the licensing person, or the licensing organization. The licensing organization took away the license, but the city or the state did not. So
I think if what you're talking about is more boots on the ground, that is be more investigators, and that would be our enforcement work group.
not really. He is talking about the people that license these inspectors. That is NASA, the contractor group license, and the union group license. They've got different letters with them, each one of them. But all of them say when they cancel a license, those people cannot relicense anywhere else. But that did not hold true. Now, I will say when this specific person's license was up, he was not able to renew from the state or the city.
Hey, this is Grayson Gill. I've got to interject here. I've got to drop. I've got to get, I'm 15 minutes late to another call. But can we go around the horn? And Alex, can you get a consensus from each of the members, which of these groups they want to be on so we can get that done?
So I'm sorry, so we have 9 board members, is that correct? Even though the 2 are vacant, correct? 9 board members?
Yes, that's correct.
Okay, so we have 4, up to 4 per work group.
Yes.
Okay. I'm sorry, Grayson, go ahead. How do you want to proceed?
Alex, can you go around? Because I got to drop. Alex, can you go around and just find out which board members want to be on which of the work groups?
Sure. Scott Anderson.
Gentlemen, I'd probably say enforcement. I want to give a quick bio for myself because when I was appointed to this commission, I was basically appointed as a public representative. And it's mostly because my son was injured in an escalator accident. And I fought it all the way through Consumer Product Safety Commission. And we actually got ASME to change building code. So I fought through it and we changed the standards that were set for escalators. That's how I got appointed to this commission. I do not work in the industry on a day-to-day basis, but I'm always interested in safety issues. So I will just say enforcement is my choice, and I just want y'all to know how and why I'm here.
Thank you. Ms. Sheila Sweat.
As I said, this is the last of my 2-3 year assignments. So I don't know if I will be re-voted in or not, but I think you had me under standard of care, but I would do any of them.
Okay. For this, I can put you down for standard of care and then go from there.
Okay.
Mr. Brian Mitchell. Oh. Mr. Brian Morris.
Okay. Yeah, Sheila, again, Sheila, you can be on multiple different work groups. I think that you want to be on the licensing group as well, because that's the one that's going to talk about the permitting.
Yes, go ahead and put me there also.
Okay.
Okay.
I guess I would volunteer for the standard of care to talk about the plan review. And with Scott on the enforcement group.
Okay, thank you. Mr. Metheny?
Oh, there you go. Sorry. First of all, it's Matheny. Every teacher I ever had got it wrong, so there you go. It's
Okay.
like Pat Metheny, the guitar player. I'm gonna stay away from education, enforcement, and licensing. I think I'll be on those two work groups.
Thank you, Mr.
Standard of
Matheny.
care. I'm sorry, standard of care for the plan review. Would you be interested in that?
Yeah, but I don't think Delisa wants me on it. I'm kidding, Delisa.
Okay.
Don't do like that, Mr. Matheny.
Thank you.
I talked
Well, you
just
are
so you
more than welcome.
just so you guys know, I was traveling from San Antonio to Victoria, and I talked to her the whole way.
Thank you.
Yeah, you could
Mr.
put me on there as well. Alex, you can put me on there as well. I got nothing to do with owning an elevator company.
For which one, Mr. Matheny?
Standard of care.
Standard of care. Okay. And then Mr. Tamez?
I'd like to be on licensing.
Okay, licensing?
Yes.
Okay, thank you. Okay, and Mr. Gill?
I believe, unfortunately, I think he exited.
Hello, everybody. My name is Anna Clark. I've been listening in on your meeting. Mr. Gill did leave. He had to step away from the meeting. So we will get your request for the work groups to him after the meeting, since he is the one that has to make the decision for everybody. But we will let him know which ones y'all would prefer to be on. And once he makes that final decision, we'll send out an email. Alex will send out an email. We'll get everybody straight and we'll get to started working. But since our presiding officer has left the meeting, we do have 3 other items to go through. So we will request somebody to volunteer to preside over the rest of the meeting since our presiding officer has left. If there's a board
Scott
member who would
Anderson
like
so moves that we have Brian Morris, since he is past chairman in our previous life.
Mr. Morris, would you like to volunteer as a presiding officer?
Yes, I thank you, Scott. Yes, I'd be happy to do that. So we can
Okay, thank you.
move this
We'll
along.
make note that you are now the presiding officer for the meeting. Thank you, sir. I appreciate it.
Okay, thank you. I
The
believe
next
so this,
item we are on is the recommendation for agenda items for the next board meeting. I'm not sure if you have an agenda, but I wanted to let you know what the next agenda item is.
I do have the agenda. Thank you. Yeah, so so agenda item G, recommendations for agenda items for the next board meeting. Does any board members have any recommendations for staff to include in the next board meeting?
This is Sheila. I would like to understand and have a definition of elevator and escalator incidents and elevator and escalator accidents. And I would like to know how this is being put out, because there are states that allow us to go into and get those immediately. And according to our figures, we had 1 in each year. And for the last year and the year before, and they have hundreds. And I don't think they have more or less intelligence than Texas, or more or less people riding elevators and escalators in Texas. And I know none of my customers, and I get involved in all ends of it, ever knew they were supposed to report accidents or incidents to anybody.
Thank you, Sheila. And again, also, you're on this board until you tell TDR no. So you're going to be here forever. So don't worry about that.
You should worry about it.
So again,
Hey, Sheila, forever's a long time.
yeah.
I know.
Well, Scott and I can attest to that, but so I think so maybe for staff, because I know there is some reporting requirements within the administrative rules. So maybe an exhibit or a discussion on what is actually in the rules and what's required of the owner. And that's obviously, well, it's kind of always been one of my hot button topics, is that the owner is the one that has complete responsibility for elevators and escalators. And the owner is the last one to know what they're supposed to be doing. But anyway, that's a process to get the owner educated. So is that appropriate, Sheila? So it's like I said, a discussion on what's reporting requirements within the rules and who's supposed to report an accident or an incident at what time.
Exactly. I appreciate that.
All right. Any other board members, any other specific agenda items? All right. I don't see any responses or anybody's hand raised. So I'm going to say that that's the only specific items from the board for the next agenda.
If y'all do think of anything between now and the next couple of months, please let Alex know. He'll be able to put it on the agenda for y'all.
Great. Thank you. Okay, now we move to item H on the agenda, discussion of date, time, and location of next board meeting. So obviously TDLR has a master calendar. Have you already kind of slotted this in somewhere?
This will be more likely than not a meeting after the work groups have met. So it should be within the next couple of months or so, but Alex will poll the board for y'all's next meeting, but it will not be 5 years in between. That'll be just a few months, I believe.
Okay. All right. I think that sounds appropriate, and it seems like it's pretty much norm now for TDLR meetings to be virtual meetings.
Yes, that's correct.
Okay.
And we will also coordinate with the newly formed work group members for meetings of their own as well.
Okay. All right. Then I believe that moves us on to our last item for adjournment. So I want to thank everybody for their time, for being here, for all the board members, seeing everybody face to face once again for a while, and all the staff that's here. So with no further topics or discussions, do I have a motion to adjourn?
Greg Tomaso moved.
Do I have a second?
Second by Scott Anderson.
Okay. If anybody is opposed, please speak up. Otherwise, we will think everybody's affirming, and we will conclude the meeting.
Thank you.
All right.
Thank y'all so much.
Thank you.
Thank you all.